The contentious case between South Africa and Israel concerns the question whether Israel has violated its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention. The distinction between the two proceedings is unaffected by the fact that the Court's orders indicating provisional measures in the contentious case direct Israel inter alia to ensure the provision of basic services and humanitarian assistance to the population in the Gaza Strip. The measures indicated seek to preserve certain rights that the Court found to be plausible under the Genocide Convention. Although the same conduct may be required of a state under different legal rules, and the same conduct may simultaneously breach multiple obligations, a determination made by the Court in the context of one obligation does not necessarily prejudge the question of compliance with a different obligation. Here, the facts that are relevant to a potential finding of a violation of obligations under the Genocide Convention are sufficiently distinct from the facts that are relevant to the determination of Israel's obligations as an occupying power and as a member of the United Nations in the present context. There are, however, factual and legal matters that may be relevant both in the present advisory proceedings and in contentious proceedings. In this respect, the Court recalls that the parties to pending contentious proceedings will have the opportunity to present evidence and arguments on questions of fact and law on the basis of which the Court will decide in those proceedings. The Court then turns to the argument that the question put to it has already been largely addressed in its previous advisory opinions on the legal consequences of the construction of a wall in the occupied Palestinian territory and on the 2024 advisory opinion. The Court considers that the current request differs from the earlier ones and concerns a question that was not addressed in the previous advisory opinions. First, the present request pertains to a specific issue that had not emerged at the time of the earlier advisory opinions. As recounted in the preamble of Resolution 79/232, the General Assembly's request was approved following Israel's adoption of legislation on 28 October 2024, curtailing the operations of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, UNRWA. Second, the 2024 advisory opinion was limited ratione temporis to policies and practices taking place before 7 October 2023. By contrast, the present request concerns conduct taking place after that date. The Court then examined the argument that the request would require it to undertake significant factual investigations and make findings on disputed and evolving matters which cannot properly be pursued in the framework of advisory proceedings. The Court notes that the case file contains ample documentation concerning the relevant facts. In the present case, the Court considers that the information available enables it to decide legal questions in a manner consistent with its judicial function. Finally, the Court rejects the argument that the request abuses and weaponizes the international judicial process. Even if allegation of abuse of process could be advanced in the context of advisory proceedings, the Court does not consider that there is any basis for such a finding in the present case. The Court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The Court then outlines the general context of the opinion. It recalls the historical background of the situation with regard to the occupied Palestinian territory. The Court next discusses how the United Nations, and in particular the General Assembly, became involved in the provision of humanitarian assistance to Palestine refugees, both Arab and Jewish. It notes inter alia the establishment of UNRWA in 1949 and the commencement of its operations in 1950. On 14 June 1967, UNRWA and Israel concluded a provisional agreement concerning assistance to Palestine refugees in the occupied Palestinian territory, to which I shall refer as the 1967 agreement. The 1967 agreement provided that UNRWA would continue its assistance to Palestine refugees with the full cooperation of Israeli authorities in the West Bank and Gaza Strip areas, and that Israel would facilitate the task of UNRWA to the best of its ability, listing a number of commitments taken on by Israel. According to the United Nations, over its 75-year history, UNRWA has become a pivotal agency for relief and assistance to Palestine refugees in the occupied Palestinian territory. Its mandate has been extended pursuant to successive General Assembly resolutions, the most recent of which extended the mandate of UNRWA until 30 June 2026. The Court observes that other United Nations agencies and bodies, specialized agencies, international organizations, and third states also provided assistance in or in relation to the occupied Palestinian territory. The Court then recalls that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out attacks in Israel, killing more than 1,200 people, injuring thousands, and abducting 251, some of whom continued to be held hostage for more than 2 years. Following these attacks, Israel launched a large-scale military operation in the Gaza Strip by land, air, and sea, which has caused massive casualties, including the deaths of tens of thousands of civilians, a large number of whom were women and children, extensive destruction of civilian infrastructure, and the repeated displacement of the overwhelming majority of the civilian population in the Gaza Strip. In the course of its military campaign, Israel has substantially restricted and for significant periods of time, including between 2 March and 18 May 2025, completely prevented the entry of aid into the Gaza Strip and its distribution to the Palestinian population, with catastrophic consequences for this population. The United Nations reported numerous attacks on school buildings and healthcare facilities in the Gaza Strip, operated by the United Nations and others, including school buildings that have been directly hit. The Secretary General of the United Nations has stated that between 7 October 2023 and 20 August 2025, at least 531 aid workers, including 366 United Nations personnel, 360 of whom were employed by UNRWA, have been killed in the Gaza Strip. In January 2024, Israeli authorities alleged that a number of UNRWA employees had been involved in the 7 October 2023 attacks, that UNRWA premises have been appropriated by Hamas for military purposes, and that UNRWA had long lost its neutrality. The United Nations immediately took steps to investigate these allegations. In this connection, the Court discusses the investigations conducted by the Office of Internal Oversight Services of the United Nations, to which I shall refer as the OIOS, and the investigation by an independent panel set up to assess whether UNRWA was taking all reasonable steps to ensure its neutrality. Notwithstanding these steps, Israel has maintained its complaints about UNRWA. On 28 October 2024, the Parliament of Israel, the Knesset, adopted two laws entitled the Law to Cease UNRWA Operations and the Law to Cease UNRWA Operations in the Territory of the State of Israel, respectively. The Court notes that the second of these laws purports to apply to East Jerusalem. By a letter dated 3 November 2024, the Ministry of Foreign Affairs of Israel informed the President of the General Assembly that Israel had withdrawn its request to UNRWA to provide humanitarian assistance to Palestinians pursuant to the 1967 agreement. According to Israel, that agreement was terminated. By a letter dated 24 January 2025, Israel informed the Secretary General that UNRWA had to cease its operations in East Jerusalem and evacuate its premises there no later than 30 January 2025. The two laws on UNRWA adopted by Knesset entered into force on that date. The Court recalls that Israel did not allow any aid to reach the Gaza Strip from 2 March until 18 May 2025. Since 19 May 2025, the Israeli authorities have allowed the United Nations to resume the delivery of limited aid into the Gaza Strip. The United Nations and the Observer State of Palestine have, however, alleged that Israel has continued to impose substantial restrictions on the entry and distribution of aid and commercial goods into the Gaza Strip. They maintain that, as of the end of August 2025, the humanitarian situation in the Gaza Strip had become catastrophic, with evidence of famine, mass displacement, extreme levels of deprivation, and the continued increase in civilian casualties, including children. On 27 May 2025, Israel launched a new aid distribution system through a private foundation called the Gaza Humanitarian Foundation and a private security firm, with only a few distribution points, mainly in southern Gaza. Israel alleged that this new system was required to prevent diversion of aid by Hamas. The United Nations, other international organizations, and humanitarian non-governmental organizations considered that this new system did not align with humanitarian principles did not meet people's needs and put people at risk, and they refused to collaborate with it. Having given an overview of the humanitarian relief situation in the Gaza Strip, the Court then turns to the scope and meaning of the question posed by the General Assembly. The Court observes that the question concerns the identification of the obligation of Israel. The General Assembly did not ask the Court to determine the legal consequences of any breach of these obligations. For this reason, the Court does not consider that it is called upon to determine whether Israel has violated its legal obligations or to address the legal consequences of Israel's conduct, including under the law of state responsibility. The Court explains that identification of Israel's legal obligations cannot be undertaken in purely abstract terms and requires taking the particular situation under the request into account. Thus, the Court states that it will base its assessment on the factual situation and identify Israel's obligations with the degree of specificity it considers warranted to fulfill its judicial function. Turning to the territorial scope of the question, the Court notes that the question covers Israel's obligations in relation to United Nations entities, other international organizations, and third states, in relation to the occupied Palestinian territory. Thus, in addition to Israel's obligations in the occupied Palestinian territory, the request also requires consideration of Israeli activities undertaken on Israel territory or elsewhere, to the extent that they concern the presence and activities of United Nations entities, other international organizations, and third states in relation to the occupied Palestinian territory. The Court further observes that while the question encompasses Israel's obligations in the occupied Palestinian territory as a whole, due to the specific reference in the request to urgently needed supplies essential to the survival of the Palestinian civilian population, it will pay particular attention to Israel's obligations in the Gaza Strip. In terms of its temporal scope, the General Assembly's request does not include any limitations. Moreover, the Court is aware